You kind of keep up with it for people, and what you've said, like what you said last week, is that still applicable? It is.
Expired. They formulated the proposal. You know, like you.
Just your family.
Hello, good evening. Can you hear me? Hi. So my name is András Juhász and I work at the European Commission's office in London. And we are organizing these info sessions for EU citizens across the UK about Brexit because we have realized that many EU citizens have questions and concerns about Brexit, what will happen to them and to their families. We organized these info sessions together with the EU 27 embassies in London, and this is the first one we organized in Canterbury. So maybe you have been following the news recently that there's a lot of talk about a no-deal Brexit, and the only message I would like to convey is that no matter if there is going to be a deal or there is no deal, you will have to apply for settled status if you would like to stay in the UK. Chris Ban, he's the lawyer, he will talk about this in detail, but this is the key message that we want to convey to you, that if you are an EU citizen and you would like to stay in the UK after Brexit, you have to apply for settled status. So the agenda for tonight is quite simple. After my short speech, a colleague from the Romanian embassy is going to say a few words because Romania is chairing the EU presidency for 6 months. And after her, Chris Ban is going to give the presentation. It will be about 40 minutes. And after that, there's going to be a Q&A with you. And also this event is live streamed on Facebook. So hopefully we'll get questions from that too. And the fire exits, I have to remind you, they are on these two sides. So if you have to escape, there's no fire drill. So yeah. Okay, thank you. So, Radhika. Oh yeah, one more thing. Sorry, I forgot that you have these publications on your seats, and there's a feedback form in it. If you could fill it out at the end and hand it back to us, that would be great. Thank you. He's going to have.
Sorry for this. I can try to speak louder, but I'm not sure if it's going to be heard also on the internet. So, okay, if anyone can, oh, now it's fine. Okay, good evening. A warm welcoming on behalf of the Romanian presidency of the Council of the European Union. I'm not sure if you're aware about the role of this institution. We began the rotative presidency at the 1st of January and we will end it in the end of June. And our role is to act as an impartial mediator and consensus facilitator in order to lead the adoption of the common positions of member states at the level of European Union and with the other European Union institutions. This is a citizen-centered presidency, and our motto is cohesion, a common European value. And when we talk about cohesion, we talk about unity. And with this, I will go straight to the topic tonight. We have, in the middle of our presidency, the sad challenge of the UK exiting the European Union, and we have to, together with the other European institutions, to manage this. Our goal regarding Brexit is to maintain the EU 27 member states unity, which probably is very obvious for you. We have been a single voice in all the negotiating process, both in Brussels, but also supporting, not negotiating, but supporting here in UK. And the European Commission here was very supportive and very active in keeping us together and working with us in our dialogue with the UK authorities, and especially on the topic of protecting your rights, the rights of the citizens of the European Union post-Brexit. So we are interested also, and we are following the orderly withdrawal of the United Kingdom from the European Union. And also, we're looking at preparing the European citizens and the companies in UK for a smooth transition towards a Europe with only 27 states, without the UK. We will cooperate closely with the other European institutions, with the institutional procedures that are going to follow. And as you know, there has been an agreement in the end of November between the EU and the United Kingdom, a very important agreement which safeguards the rights you have acquired in the UK. And we do hope that there is going to be a deal, and that withdrawal agreement, that agreement that has been reached, will be in place. And we are facilitating, as a presidency, any discussions on this topic. But as Andras said earlier, even if there is no deal, the UK reassured that the European citizens here will have pretty much the same rights that have been agreed between the two parties, with some changes that will be evidenced by our colleague, the lawyer who is going to speak to you tonight. And what I would like to say again, I would like to underline that our presence here, this result of the work of the Commission and the EU member states' embassies, is an example of unity. Our main message is that in the next period you will have to apply for the new immigration status in the UK by the end of the deadline, whichever that deadline would be, and our colleague will tell you more about this. But also we would like to ask you to be goodwill ambassadors and to take the information that you acquired tonight, and the information maybe you already know, to your families, to your friends, acquaintances, and towards your communities, because that is what we would like to invite you to do, and that's what the European Commission present here and the representatives of the other member states will work together towards you being informed and for your rights to be respected. Thank you very much, and I hope you have an informative session this night. Thank you.
Thanks, thanks to Raluca and to Andras for the introduction. So, as they've explained, my role here tonight is to hopefully give you some useful information about what lies ahead for European citizens already living in the UK. I will also touch on what will be the situation sort of as of March 29th of March 2019, assuming that is Brexit Day, and what will change immediately, because there are some very significant possibilities ahead of us, and a lot of this does relate to a deal or a no deal scenario. But I would also sort of, just to start this, to say that for those people who are living here, in theory, all of this kind of confusion about the deal or no deal shouldn't be have a huge effect, because the UK government has said that they're going to run the EU settlement scheme irrespective of whether there is a deal or a no deal. So that's good news for people who are already here. There will be some sort of key differences which we'll talk about as the presentation goes on. I'm an immigration lawyer, and what that essentially means is that I'm someone who deals with UK domestic immigration law and someone who also deals with European free movement law as it stands today. So there are two strands of law that cover the legal right to reside in the UK. And up until the most recent events in the referendum, they've been very two distinct areas of law, but they're now sort of coming together, and they'll form a single strand of UK immigration law as this situation progresses. Sorry, I can't see my computer very well, so I'll have to look up here. But essentially, the current situation, we won't spend too long talking about what the sort of current free movement law is, because everyone's here under it, probably. It's essentially very light touch in the UK. You come in and out of the airport or the port using your national ID card, your national passport. When you apply for a job, or go to university, you'll be asked to present your evidence of your identity in the same way. And by and large, that's about as far as free movement law goes. You don't have to register with any authority. You don't have to register an address with the municipal authority. You don't have to apply to the Home Office for some kind of proof that you are here under free movement law. We've never operated that kind of system in the UK. It's been very light touch so far. The only people who, or the majority of people who will have had some involvement with the Home Office under free movement law will probably be non-European family members of a European national, because they tend to have to go and ask for a document to show they have a right of residence, because they wouldn't, it wouldn't be automatically obvious from their nationality. So this is the referendum. We all know the outcome of the referendum. What that means as far as the rights of Europeans living in the UK goes is that at the top line there, European free movement law is going to end. We don't exactly know when it's going to end at the moment, but that is one of the main aims of this government, and it was one of the big topics of the referendum, as you'll probably recall. Because the government has chosen to end free movement, they have got to create a new system of residency rights for European nationals, because you'll no longer be here under free movement law. And this is what is known as the European Settlement Scheme, and you'll hear the term settled status used quite a lot. That refers to the same thing. That scheme has been based on the text of the withdrawal agreement that was sort of first initially published in March 2018 and then signed off from both parties, seemingly the final text, in November last year. And so the settlement scheme is very much based on what is in the withdrawal agreement, but it's written into UK law through the EU settlement scheme. So as I've said before, and the reassuring thing as far as the no deal goes is that it will still be implemented even in the event of a no deal, and we'll talk about that in more detail as we go along. So just to kind of run through the kind of the structure, we'll talk about the main requirements of the EU settlement scheme, and that would apply to deal or no deal. The majority of it applies to deal or no deal. And then obviously the changes if there is a no deal, things that people need to be aware of. And then a little bit about what will happen to the immigration system in the event of a no deal if Brexit Day is March 29th of March 2019. So this is a little quote that's quite useful to kind of, I guess, to demonstrate to people that this does really, really apply to everyone who is is an EU national and an EEA national and a Swiss national. Everyone is going to be asked to do something, except for a very small proportion of people, which we'll examine in a bit more detail. But really, everyone needs to know that this is mandatory, it's not a choice. We have some key dates, some of which have passed and some of which are looking ahead. So basically, with the settlement scheme, we've had two, what they've called, the Home Office called private beta stages, so test stages to see how people apply, how the Home Office application system works. And so some people already have gone through the scheme. Perhaps some people sitting here have already gone through the scheme. The private stages have been quite small in comparison with the amount of people that will have to go through this. There are some results that I'll go into in a little bit, but it's not a great reflection of the vast majority of people who'll have to go through, which is probably in the region of 3 to 4 million. We are currently have what's called a public beta stage, so it is actually open to a lot more people at the moment to apply. No one has to apply at the moment, it's a choice, but then we'll get to the deadlines of applying as we go further. 15th of January we had the rejection of the deal in the UK Parliament. We've had another vote this week on apparently where we get the way forwards as far as the government's concerned. We'll see what that results in over the next few months. We still have the 29th of March 2019 as the date the UK is leaving the EU. There's a question mark, obviously, because there's talk that it could be extended, but we'll assume that's the leaving date for the purposes of talking tonight. That means that by the 30th of March 2019, the full settlement scheme has to be up and running, and that's the intention. And then if there is a withdrawal agreement, we have a period up until the 31st of December 2020 where it's called a transitional period by the EU and implementation period by the UK government. It essentially means that EU law, as it stands today, will carry on for that period whilst the preparations are continued to be made for the UK to leave. And then as far as the settlement scheme is concerned, we have two dates, which we'll again talk a bit more about later. The 31st of December 2020 or the 30th of June 2021. And that is the deadline to apply under the EU settlement scheme. The first date applies to a no deal. The second date of June 2021 applies to if there is a deal. So we'll talk first of all about the withdrawal agreement and how the settlement scheme under the withdrawal agreement, because that's the rules as the scheme's been written based on that, and that's what we see today. Just to kind of note, I've just realised people have a presentation. So this is a document that we've continued to prepare, and since we started doing these talks, and try to update it with the announcements and trying to keep sort of live with the politics of the situation. So invariably, the presentation changes almost on a daily basis, it feels at the moment. So the one that you have, which was only produced a couple of weeks ago, has now been superseded, but the information in it is by and large correct. It's just that we're trying to make it as relevant as possible to the sort of the politics as it moves forwards. So under the settlement scheme, people are applying for they're applying for a UK immigration status, and it will be one of two statuses that people are given. And the first one is called settled status, which essentially means permanent residence, indefinite leave to remain in UK legal technical terms, and that is for people who have lived here for 5 years already, or in some limited scenarios, people who've had less than 5 years but a special circumstance applies. But to get settled status, most people are going to have to do a qualifying residency period in the UK of 5 years. If you're someone who has come to the UK a bit later on and you haven't got the 5 years residency at the point when you're applying under the scheme, you will probably be issued with what's called pre-settled status. And that is, as it says, it's the status before settled status. So what it allows you to do is build up a 5-year qualifying period to then go and apply for settled status at a later point. So those are the two statuses. There's no more than that. It will be an online application form that you'll have to complete. It's fairly short, fairly straightforward. At the moment, if you wanted to apply, you would have to use the Home Office Identity Chip Checker app, which is available on Android phones, or some Android phones, it seems. That is if you wanted to apply now. You won't have to use the app in the full rollout of the scheme. There is going to be a paper form, but it will be very limited to probably to vulnerable groups. Because you have until the 30th of June 2021 to apply, it means that you don't have to all apply now. You don't have to apply on the 30th of March. You can choose, and for some people it may be beneficial to wait because they might accrue those 5 years sometime before the 30th of June 2021. Right. What is the criteria of the scheme? And as I've talked about 5 years residence or less than 5 years residence for pre-settled status. Oh, excuse me. And that is basically what is being looked at. Unlike free movement law, your actual activity in the UK is not being examined in any significant way. It's just about whether or not you're living here. And that means for those people who maybe have applied under the current EU system and have had some form of rejection based on the comprehensive sickness health insurance or not holding that kind of refusal wouldn't occur under the settlement scheme because the Home Office is not going to apply a requirement for some people to have insurance. So it's just about residency. So if you've had periods of work and then periods of unemployment or periods of benefit claims or anything like that, it's not going to be factored in. It's just about living here. And that's good news because it means that the vast majority of people will be covered. It's in bold up the top because everyone has to apply. And this includes those people who have already gone through the European permanent residence process, because a lot of people after the referendum result felt that they wanted to get a document to sort of secure their status, to show they had a status in the UK, and that's resulted in quite a lot of people applying for an EU permanent residence document. It's a blue document about that wide. If you have one of those, great, it will help you in the scheme, but it's not going to survive the end of free movement, and you still have to apply under this scheme. And as I've said in the next line, failure to apply by the deadline may result in essentially an unlawful status in the UK, and that can lead to the hostile immigration environment, removal from the UK. So there is a massive, massive incentive for everyone to apply and to let everyone who they know in the same position that they need to apply as well. If somebody holds a status called indefinite leave to remain already, and that would maybe apply to some European nationals who've been here an awfully long time, like even before the UK joined the European community, or some of the sort of the member states who've joined at later periods. There are some nationals who already have this status of indefinite leave to remain, which is the UK immigration status. They're not required to apply under the scheme, but we would probably encourage people to do so anyway, because they can swap the indefinite leave to remain for settled status. And it just means that further down the line, hopefully there'll be less confusion about the fact that someone holds settled status will be easier to prove than perhaps a historical grant of indefinite leave to remain. For those familiar with the Windrush situation, that's something that's sort of come about because people could no longer prove they had indefinite leave to remain. So it's the same possibility here. So we'd say for everyone, apply under the scheme, because then you'll be able to prove your status relatively easily. So under the withdrawal agreement, everyone who's a member of the EU27 is covered. This includes Irish nationals, but because of the special agreement between the UK and Ireland, the common travel area, Irish nationals aren't required to apply under the scheme, but they can do if they want to. If someone is a non-EU family member of an Irish national, they will still need to apply to show that they have legal residence. Non-EU family members of anyone in the EU27 will apply or be able to apply. Now, although the withdrawal agreement doesn't cover the EEA states and Switzerland, the government has reached separate agreements with those countries, and they will be included in the scheme. So they're included in the settlement scheme without being covered by the withdrawal agreement, if you like. If someone has gone through perhaps the permanent residence process already, and that's led to them becoming British by naturalisation, then they would be a dual British national with their EU member state nationality. They can't apply under the scheme because your right to reside here comes from your British nationality. But if you have family members who may need to apply because they're non-EU, or if they're not British themselves, if they're EU, they will still be able to apply under the scheme. And certain rights that come from the withdrawal agreement that don't relate to legal residence as such would still apply to people who've become British by naturalisation. So when we talk about citizens and family members, they have to be residing in the UK before the 31st of December 2020, so the end of the transitional period. Anyone who hasn't taken up their residence in the UK by that point would fall under the new immigration system, whatever that will look like. So it doesn't mean necessarily that someone has to be here on the crossover into the 1st of January 2021 if you've got a long residency period, but it just means that if you couldn't show that you're already living here by that date, then you wouldn't be considered to be covered by the settlement scheme. Some family members who aren't living here with you at the moment, perhaps, they will be able to still join you after the 31st of December, as long as you have your residence here before then. So family members, and this closely mirrors European free movement law. There's types of family members who can be sponsored by an EU national, spouse, civil partner. Durable partner means essentially an unmarried relationship that is serious. The Home Office thinks that that's a 2-year cohabitation period and above, but that's not a strict interpretation. Dependent children means children under 21 are covered, and then if you have dependent parents or grandparents, they can also be considered your family member. And so all of those family members, it's relevant to them if they're non-EU nationals, because if they're EU nationals, those people can apply in their own right if they're living here. But if they're non-EU nationals, you will be sponsoring them effectively, or if they're not already living here by the end of December 2020, you could sponsor them to come to live with you in the future, if the relationship exists before the 31st of December. There is another category of family member under free movement law, which is more extended family members, so sort of brothers, sisters, uncles, aunts, cousins. They can sometimes be sponsored under free movement law, so they are covered by the withdrawal agreement, but they have to have been here by the 31st of December 2020. So you wouldn't be able to sponsor someone in that relationship after the end of the transitional period. If you have a spouse who is not an EU national and they have children who aren't necessarily your children, that spouse can still sponsor their children. They're still covered, even though your spouse isn't an EU national and their children may not be. So there's quite a broad range of people who might not necessarily be EU nationals who will fall under the withdrawal agreement and the settlement scheme. If you have children born outside of the UK after the 31st of December 2020, you would still be able to sponsor them to come and live with you in the UK after the end of the transitional period. But family members essentially who arrive after that date have to apply within 3 months to get their own visa under the settlement scheme. Fees, right? So this is one of these things that's changed very recently, as you might be aware. So to a somewhat surprising announcement on the 21st of January, the Prime Minister said that no one would be charged to apply under the scheme. So the fees of £65 and £32.50 for under 16s got swept away with one announcement from the Prime Minister. So that's fine. If you have already applied and if you already have paid that fee, you will be refunded in time, but it's going to take a piece of legislation to do that. But anyone who applies in the full scheme that starts by the 30th of March won't be charged. So that's a small piece of good news, shall we say. When it comes to applying, this is what you have to do to make sure that the Home Office will process your application. You will have to make what the Home Office considers a valid application. You will have to prove your identity and that you're a national who's covered by the scheme. You will have to show how long you have been living in the UK for, so the Home Office can decide whether you're a pre-settled status person or a settled status person, and there are criminality checks for those who are over 18. So what is a valid application? So it essentially means going through the procedural hoops that the Home Office sets. So it's filling out the online application form. At the moment, it's still paying the fee because you still have to and it will be refunded. You have to prove that your identity, and you have to enrol a facial image so that they can check this against your identity document. If there's a problem with whether or not your application is valid, in principle you would be contacted by the Home Office to try and correct the error. So identity, so obviously for EU nationals, this at the moment, it can be done using your passport or a national ID card. If you're a non-EU national, you can use your passport or a document that has been issued by the Home Office in the past. With the app, what it does is it essentially scans the chip in a biometric passport and it communicates that data to the Home Office. It does not work on iPhones. It only works on Android phones. And in the test phases that have been sort of run to date, it's worked okay, but it has been patchy at times. But it doesn't. As I say, you don't have to apply using the app. It's just it avoids you having to send your ID document to the Home Office because most people don't want to to send their ID in the post and things like that. If you do have to send your ID document to the Home Office, they will try and process it quickly and send it back to you within a few days. So the app, it scans your passport, and that communicates the information that's held in your passport to the Home Office. And then what you do is you complete the rest of the online application form, which is asking you things obviously like your names, if you've had any other names. So if your name is sometimes spelled differently between sort of your national spelling and an international spelling with umlauts and things like that, or if you have a married name that you've changed, then you'll be give that information in the online application process. So some people may struggle with the online application side of things, and the idea is that for those groups, for vulnerable groups, the Home Office will set up assisted services. They've released some funding for organisations who would help people who are going to struggle with the technology side of things, which inevitably some people will. But the idea is that most people can make the application by themselves, and it's relatively straightforward. If you don't have an identity document for some reason, and this will apply to a significant number of people, there is a clause in the scheme which says the Home Office can accept some other form of identity, something like a birth certificate, for example. But to be honest, the Home Office are going to be quite tight on this. They do not like not accepting passports and identity documents. So if your passport or your ID document's coming up for renewal, and you need, before you apply, you do need to go to renew it and things like that, because you are expected to provide an ID document. Right, so once you have established you're an EU national or you're a family member of an EU national, then you move to the residency side of things, and this is the sort of main part of the application. So what you do as part of the application, if you have one, is that you give your national insurance number, and by giving your national insurance number, the Home Office can then run two checks on your status, which is with the HMRC and with the DWP. And what they're checking for, they're not checking for sort of volumes of tax paid, they're not checking for benefits claims, they're checking to see if you are here, because HMRC tax records are quite useful to show that people have actually been residing in the UK. They are going to be relatively limited checks. So, for example, HMRC isn't going to look any further than 7 years backwards, and the DWP checks are only going to look at certain benefit claims. So it may be that you'll think that your national insurance number should put you as resident in the UK, and then you'll find out from the Home Office, oh, actually, we're not sure, which may come as a bit of a surprise and has done to certain people in the testing phases. But the reason for that is because they're not incredibly sophisticated checks that they're running. So it doesn't mean that you can't show that you're resident, it just means that the automatic stage that the Home Office will do for you hasn't shown everything that you would hope. So if that's the case, then you will be told at that point, the Home Office will say, perhaps something along the lines of, we can see 3 years of tax records for you. Have you been here 3 years, or do you think you can show that you've been here for a longer period? So some people might have only been here 3 years, and you'll just say, yes, I've been here 3 years, those are my tax records. But if you've been here for a longer period but maybe weren't working, then you can say, no, I have been here longer, and I'm going to produce additional material, additional evidence to prove this. And so what you will then do is you'll be asked to scan in documents which prove, according to the Home Office, prove that you're resident in the UK. And there is a list of documents that they will accept as evidence of residence. And this includes things like council tax bills, bank statements, NHS appointment letters, and the whole kind of myriad of things that you would just gather in your everyday life. They will be accepted in most situations as evidence of living here. So the idea is that the automatic checks on HMRC and DWP cover most people, and that you don't have to do too much yourself. But realistically, there's going to be lots of people who are going to have to produce their own evidence. So if you only get a national insurance number at 16, so if you're under 16, it might be that you need to use completely your own evidence. If you're a student and you haven't engaged with HMRC, you're going to have to use things from your university. So it very much depends on your own circumstances. But the idea is that you are able to produce this material that shows that you've been living in the UK. So there is a legal definition of what residency actually means, and this again is taken from free movement law. And what it says is basically, if you are living in another member state, then you have to be resident in that member state for more than 6 months in any 12-month period. Otherwise, you're not actually living in that member state. So, and that 6 months, that can be a 6-month chunk, or if you accumulate over 6 months outside of the member state, then that would also break your continuous residence. So it's relatively generous, and it doesn't apply, you know, most people, if they're working in a sort of normal pattern and take annual leave in other countries, they're not going to break their continuous residence. If you're an academic who has to do lots of overseas postings, you might have a bit more of a hard time meeting that requirement. So it sort of depends on people's personal circumstances. You are, if you've got 5 years worth of qualifying residency, in one of those 12-month periods, you are allowed sort of an exceptional absence of over 6 months, so long as it is less than 12 months, providing it's for one of those reasons that they've set out in the sub-bullet points. If you have to have done military service, you're not considered to have broken continuous residence for all of the period that you're outside. So that's the rules on continuous residence. And then once you've sort of established how long you've been here, there's going to be criminality declarations that you have to make to complete the application. So this is for over 18-year-olds, and you are going to be asked 2 questions. One is about the UK, and then one is about any overseas convictions. And so it will cover, as I say, it covers any criminality in the UK or abroad. Now, what happens if you do have a conviction? Because you will be obviously asked to declare it. And so what the withdrawal agreement says, and this is written into the settlement scheme at the moment, is that any criminal conduct that was that carried out before the 31st of December 2020 is covered by the European standards, the free movement standards of criminal suitability. And that is it means that if the UK wanted to remove someone, deport someone from the UK on criminality, they would have to show a level of threat to the UK in order to carry out that deportation, because European law says that that's what the UK has to show. If after the 31st of December 2020, the Home Office they'll apply UK standards of deportation criminality, which are much lower. So it's essentially, the easiest way to think of it is it's easier to deport someone under UK immigration law than it is under European free movement law. So there's a distinction between conduct that happens before the end of the transitional period and conduct that occurs after it. Again, I mean, if someone has a conviction, particularly if someone served a sentence in the UK, they will probably have already had any deportation action that was going to be taken will probably have already happened, because the Home Office seeks to remove people. And so it probably, anyone who's coming up to apply who served in the UK isn't going to have any issue. People who have a conviction from another country will probably take a bit longer for their application to proceed whilst the Home Office looks into it. And then this essentially says that if you're someone who we think has got a criminal conduct that we can remove under, then we're going to issue a deportation decision, and obviously we'll refuse you under the scheme. Then there's a second part to what's called the suitability requirements, and that is if people, for example, if they don't declare that they have criminal conviction, and then it comes out during the process through the Home Office checks that they do, they may well say that someone's given false information, and that was material to the decision that was made, and therefore they're refused for not giving the correct information. And there is a final refusal part on suitability, which is what's called for the non-exercise of EU rights. This is quite a controversial clause because the Home Office has had, and the government had said, we're not going to look into whether someone's using their free movement rights. We talked about the comprehensive sickness insurance. That's part of free movement rights, but the government said, no, we're not going to look at that. But they put in this clause into the rules, which said, actually, in some scenarios, maybe we will look at it. And it's not quite clear why it's there or how it's going to be used, but it's a little bit of a concern, but it shouldn't really, by and large, affect most people. We don't expect to see refusal decisions on that basis for the majority of applicants. But you just need to know that it's there. I know it sort of sounds a bit scary, it's not a nice thing, criminality, but it is in the rules, but most people it's not going to affect. Okay, so when you've gone through all of this process, you then get to a decision. And so far, as you'll see when we come to talk about the two test phases, everyone has been granted a status. They've either been granted pre-settled or settled status. So, and the Home Office has repeatedly said, the government has repeatedly said, we're looking for reasons to grant people status. We don't want to refuse people status. So ideally, everyone is going to get a positive outcome. And what that means when you get the status, well, what does it look like? Well, it looks like a digital status is how it's going to be given to you. So you won't be sent a card, an ID card or anything like that if you're an EU national. You will be sent a coded login that will give you access to a server, and you'll be able to see that you have digital status, and it will say settled or pre-settled. And that's the information that's provided, and the purpose of the information is that anyone who needs to check that you legally live in the UK, and this would be after the end of the transitional period, because in the transitional period it wouldn't really matter because things will carry on as normal. But afterwards, people, certain organisations will need to look at your status perhaps, and that would be people like employers, landlords, the NHS, banks to open up bank accounts, Department of Work and Pension, and Immigration Services. Obviously, once you're travelling in and out the UK after the end of free movement law, the Immigration Services are going to need to see that you have a status. So that's why you're being given this digital status, is that people will be able to see that you're someone who is covered by the settlement scheme. Now, there is just a couple of other points just to make, and these are not the second bullet point down. In terms of, there are other rights for citizens other than just the legal right of residence contained in the withdrawal agreement, and it's things like reciprocal health care and pension rights and the access to certain social assistance. And the idea of the withdrawal agreement was it preserved the current situation, what's called the social security coordination rules between the UK and the EU. The idea is that if you earn your pension in the UK and you decide to retire back to your home country or to another country within the EU, you could export your pension that you earn in the UK, your state pension, to that country, and it would be paid to you there. And that's the idea of coordination between the member states, and the withdrawal agreement preserves that as well. So that's not strictly speaking to do with legal residence, but it is a very important part of the withdrawal agreement. Now, the rest of that, as I say, it's just about, I think employers is going to be the biggest thing for people because, as I say, employers to date, for European nationals, they'll employ you if you have a European passport or an ID card. But after the 1st of January 2021, the government is going to start asking or requiring employers to check that you're someone who has legal status, and that's where you'll be giving your employer a login to your digital status. Just the one final point is that if you have a non-EU family member, they are going to still be given an ID card rather than a digital status. That's a decision the Home Office has made. But if you are given pre-settled status, not settled status, then there's a couple of things that you need to bear in mind, and mainly it's to do with that continuous residence clause, because it still applies to you. Because you're in those first 5 qualifying years, it means that you have to be here more than 6 months in any 12-month period. except for the reasons, the one-off absence of up to 12 months that we discussed. So when you're in a pre-settled status, you still have conditions on how long you can be outside of the UK. And also it's important to know, if you have pre-settled status, that you have to apply for settled status in the future. It doesn't convert automatically into settled status. Because you've got one doesn't lead to the other one. So you do have to know that you'll make a second application. What pre-settled status will be granted for 5 years, regardless of how long you've lived here. So if you've been here 1 year, you'll still get pre-settled status for 5 years. If you've been here 4 years, you'll still get pre-settled status for 5 years. So it won't acknowledge the length of time you've already been here. It's just going to give you a blanket 5 years. And that doesn't mean you have to wait till the end of the 5 years of the pre-settled status to apply. It just means that that's how long you've got it for. And you can apply for settled status as soon as you've got over that 5-year threshold. Okay. We've said with the criminality clauses, you can lose your pre-settled status if you commit criminal offences. If you get settled status, so the permanent residence, and the one that everyone we hope will get to eventually, what that means is that once you hold that, you can live outside of the UK for up to 5 years in any one stretch of time without losing that status. So all of that 6 months and 12-month residency criteria falls away because you've got settled status. And so it's quite a generous, there's actually more generous than the current permanent residence free movement allows you, because that allows you 2 years outside the country, whereas this is 5 years. So it's pretty good. And what that means is essentially you just have to come back in the 5 years, you reset, and then you can continue living somewhere else if that's what you choose to do. Again, the criminal convictions, it applies. You can have it taken away in certain scenarios. Once you have settled status, you can apply to become British using that status, because it's a permanent residency, and that's what is the key to becoming British, is that you have a permanent residency here. But you're not required to do so. It doesn't mean that you have to continue on that path. Your settled status is sufficient evidence, and it's a right to live here permanently. But some people will perhaps choose to become British. If you get settled status, and you've had children who were born in the UK who weren't British at birth, because there's sort of complex rules about whether children are born British or whether they're not. But if they weren't born British, but they were born in the UK, once you have settled status, that child can apply to be what's called registered as British, as long as they're still under 18 years old. So some people might choose that for their children after they obtain the settled status, and it's perfectly legitimate to do so. So just to cover, if you did want to become British having acquired settled status, there are a couple of things to note. The first one is that if you're not married to a British person, then you have to wait 12 months before you apply to become British. And there are other criteria to becoming British. It's not just I have settled status, so I'm going to become British, but I'm not going to. It's a different topic completely. So, but it's just to know you have to hold it for 12 months unless you are married to a British person. So that sort of covers hopefully the rights and how it will work and how you'll see that you have these rights. A couple of things to say about the process. These are all the aspirational statements that the Home Office and the government have made about the system. This is how it's supposed to be operating. Obviously, the proof of this is in the pudding, as we say. We hope that this is how it's going to operate, but there has to be a lot of investment on the Home Office side to make it work like this. Even though the government has obviously said we don't want to refuse people, no one's going to be refused, it will happen. Someone's going to get refused. So if that does occur, then this is what you can do about it. You have the right of appeal to an immigration tribunal, which is in front of an immigration judge, and you will be able to present your case and why you shouldn't have been refused. There won't be many refusals. I do believe that, but some people may have to go through this process. If you do, it costs £140 to appear in front of a judge. You can get that refunded to you if your case is successful in some situations. if you get a refusal decision before the 31st of December, you could just apply again. There's no barrier to trying to make another application. It would sort of depend on what the reason for you getting a refusal would be. So, but as I say, hopefully this is an absolute minute or no one. It would be nice if there's zero, but if there's not going to be zero, then let's hope that there's very, very few. Okay, do please apply before the deadline, because if you don't, then you're potentially into the hostile environment, which is just not a great place to be. The Home Office can allow you to apply after the deadline, but they will expect to see a good reason for the non-application within the time frame, and that really does mean a good reason. It's not, I forgot to apply, sorry. It is, you were not able to apply for something very serious. But yeah, so do apply before the deadline. Saying it again, I would put 10 slides up with the same thing if I thought it would sort of help drum in the message. I guess the final thing to say, and so obviously we have this has all been done in the context of the withdrawal agreement. If there is a signed off withdrawal agreement, the idea is that the monitoring of the scheme, the rights that you are given under the withdrawal agreement, are jointly monitored between the UK and the European Union in using the sort of mechanisms of the EU. What that means is that the Court of Justice of the European Union will still give decisions about people's rights under this and whether or not the UK is respecting those rights. They can do that for up to 8 years after the implementation of the withdrawal agreement. So there will be hopefully some good judicial oversight. Whilst we would be in this transitional period up to the December 2020, the European Commission would do the monitoring of the scheme. And after that date, what would happen is it would the monitoring would be passed over to what's called the Independent Monitoring Authority, which would be a government body set up by statute to take, essentially they will look for systematic breaches of the withdrawal agreement. So they wouldn't necessarily deal with individual cases, but they would look for if there's trends that are somehow offending the rights in the withdrawal agreement, then that would be monitored in that way. Because the withdrawal agreement is an international treaty, it does have, essentially from a lawyer's point of view, the highest level of protection that you can get and a good level of oversight to make sure that the scheme is run properly. So that's why, from a lawyer's point of view, we want a withdrawal agreement, and for you, because it gives you some certainty, and it means that it's not, I suppose, the UK marking its own homework. It's the UK plus the EU. But we do have to talk about it. So it's such a great dance. What happens if there is no deal? So this is about the scheme. If there's no deal in other areas of what the world we know, that is it's too much to deal with. But this is about the scheme. The government basically, they published a paper on the 6th of December saying this is what we'll do, and it says, the good news is it says we'll run the scheme. Great. And all the qualifying criteria that we went through, the 6-month continuous residence, the 5-year qualifying for settled status, the family members who are covered by it, it's all the same. But there's a couple of dates that are different. So what essentially, whereas under a withdrawal agreement, anyone who moves here before the end of December 2020 could be under the scheme. If there's a no deal, then the government will cut off eligibility for the scheme as of the 29th of March this year, if that's Brexit Day. They will say anyone who comes after that isn't part of this scheme. They can't stay here on a permanent basis using the scheme. Okay? So for everyone probably sitting in this room, that doesn't make a difference because you're already here. But there's a change to the deadline of applying. It becomes the 31st of December, not the 30th of June. So a shorter period, which could have the impact of more people missing out on that deadline. Again, hopefully not. Part of the info sessions that we do, part of the dissemination that the Commission does is to make sure people know about this deadline. But the deadline comes about sooner. And if there is a refusal, rather than having an appeal to an immigration tribunal, then there's what's called an administrative right review, which is an internal Home Office review. So it's, some people would say it's less independent than having a judge. So reduced appeal rights is another outcome. If you are looking to sponsor family members who don't already live in the UK, certain dates also become very relevant, and that is under the withdrawal agreement, if you're married before the end of the transitional period, then you would be able to sponsor your spouse at any point to join you. Under the no deal scheme, the application has to be made before the 29th of March 2022. So it sort of gives 3 years for people to sponsor whoever the family member who's not in the UK to join. And after that, it's not that they would never be able to come here, but they wouldn't be under the scheme rules. They'd be under UK immigration rules, which are much stricter as far as sponsoring family members. And it also basically it says that these dates are a little bit complicated. There is a link to the actual policy if you really fancy a read of it. But what it says is that if you, after the 29th of March, or after Brexit Day, you then enter a relationship with someone and you may get married in that period, you can actually sponsor them under the scheme, but they have to be sponsored before the 31st of December 2020. So you have to you don't get till 2022 to make the application for them to join you. You get an even shorter period of time. So it's an impact of family members, because as I say, most people are already here, so they fall under the scheme, but it's just your family members who have a bit more of a squished time frame to make the application to join you. The deportation of people with criminal convictions becomes much easier for the government. They will apply the UK standards as of the 30th of March, so they'll lower the threshold for deportation. Again, hopefully it doesn't affect too many people. Then there's things like, I mean, again, because it's covered in the withdrawal agreement, it's not the residency right side of things, but the pensions and that side of things. The government has said that they will try to honour what's essentially written in the withdrawal agreement. They want to have this exportation of pension rights still there, but it's going to require reciprocal agreements made with the EU or the member states. So that side of things becomes much more complex for people. And obviously, because we don't know if we're going to be there or not, we don't know what it will look like. But those are the major differences. So you can see that the scheme does run pretty much either way. It's just a little bit more thought has to go into it if there's a no-deal situation. So this final part is not really about the EU settlement scheme, but it's just it's an announcement that's been made this week, and it may impact on some of you, or it may impact on people you know who are thinking of coming to the UK after Brexit Day. So what it basically says is that in the event of a no deal, so rather than, because we won't have this transitional period where EU law runs, the government will look to end free movement law as soon as they can after Brexit Day. But that would cause a huge problem for businesses and for people's lives and for people coming through the ports, because they suddenly are not coming under free movement law anymore. So what are they coming to the UK under? How is this going to be checked? Also, because people who are already here, who are eligible for the settlement scheme, may not have gone through the process of applying yet, what happens to you with your employer? How do they know that you're someone who's eligible for the scheme if you're not required to apply until December 2020? So you can see that this is confusion, and it's an interesting policy from the government. But what they basically are saying is that you won't really see any difference. You're coming in and out of the UK. People who are not even here yet, who are coming after Brexit Day, they'll still go through the e-gates at the port, at the airport. They won't be asked any questions. They'll be just granted entry, no problem. But what they won't be allowed to do is apply under the eligible the settlement scheme. And so what the government basically says is that if someone's coming here after Brexit Day, they want to stay longer than 3 months, so they'll be given 3 months automatically to visit or whatever. But if they want to stay after 3 months, then they've got to go and apply for an immigration status, like a temporary visa. And so this will come as a shock to EU nationals who've never had to do this before. And it doesn't apply to people under the, who are eligible for the settlement scheme. It's for people arriving after that date. But there's going to be questions about whether they'll know what to do. But that's the idea. And then those people will be given a temporary visa, which is for 3 years, but they won't be able to settle here on a permanent basis. And then, you know, so there's, like I say, it will be a big change for people, and they won't necessarily know that they have to apply for this visa after 3 months. And if they don't, in theory, the government can take enforcement action against them. And so there's all sorts of, there will be a lot of confusion around this. As I say, this is more for information for those of you who know people who might be thinking about coming, rather than for people under the settlement scheme. This is just more, again, this you can have access to this presentation through our website. So it just gives you, that's only been announced on Monday, which is why it's not in the presentation you have. But if you want to look at it, then you can see the link, and it tells you about what those people applying to come here afterwards will be going through, and what will happen to them in the future. But essentially the bottom line is they won't be able to settle here on a permanent basis because free movement's gone, and the government's moving to a new immigration system as of January 2021, which is nothing like free movement. It's all about skills, it's all about earnings. It's a much more restrictive approach. The free movement days are finished as far as this government's concerned. So just a couple of stats. I mean, you could go on with the stats on the private beta stages for the settlement scheme for quite a while, but really all you need to see is that everyone was granted, but they were very small groups. So the first one, PB1, private beta 1, 1,000 people applied. They were all granted. PB2, private beta 2, 30,000 people applied. Everyone was granted who had a decision by the time they produced their report. The split between settled status and pre-settled is about 2/3 settled, 1/3 pre-settled. No refusals, but there were 11 challenges to the outcome. So when someone, basically what that means is the Home Office said, we don't think you've been here 5 years, and someone said, no, I have been 5 years, I'm going to challenge that decision. I want that looked at again through the administrative review. And what happened was 10 of those were overturned from pre-settled into settled, and 1 of them was upheld. So it was pretty short, the processing times. Most cases were decided within a week, so not too bad. And the HMRC checks and the DWP checks were not quite as helpful as I think people expected. And that's a lesson that we've learned, and that's kind of why I focused on it a bit tonight, because just everyone who is going to go through this might hope that those checks are going to be wonderful, but they may be a little bit less sort of useful as far as residence is concerned. The mobile app, you know, the government admitted that the mobile app didn't always work. Even some Android phones it didn't work on. So there are some teething issues there, which hopefully will be eradicated. And as far as sort of vulnerable applicants are concerned, which there's an estimated around 10% of people who need to apply would be classed as vulnerable. They haven't really gone through the process yet, not many cases, so we don't know how those kind of applications are going to be processed, because they're the ones who are most likely, I guess, to not be able to show that they fall under the scheme, and so there's concerns there. The Home Office will admit it themselves, these are not results that you can apply to the 3 million people who go, 4 million people who go through it afterwards. They are very much isolated, small tests with the idea of seeing how the technology worked, and in theory where lessons could be learned. So, sorry, there's reference. I should just say one more thing. We are into, obviously, as I said, we're into public beta testing as of the 21st of January, so that means that anyone who holds a biometric passport and can get hold of an Android phone can apply at the moment under the settlement scheme. So, again, lots of people will do. I've seen it working with people who've come to me to to run through it. So I've sort of, again, what I can see from my own experience is still relatively quick results, like within a week at least, and sometimes within a couple of days. So fairly quick. I think the Home Office told us at the last meeting that we had with them that 60,000 people have applied under the public beta stage so far. So the numbers are going up. But if you don't have to apply under this stage now. It's going to go live as of March. And as I said, there's an endless amount of material you can read about this. Some of it's very useful. The caseworker guidance is quite useful because it tells you what the Home Office are looking for if you've got any doubts about how to make your application. There's information about the 2 private beta stages. And then there's obviously the organisations who are out there providing information and hopefully helpful advice for people going through this, because everyone is going to be going through this. So there you go. That's a whistle-stop tour of the settlement scheme. We could go for days, but we won't. Oh, we've seen that.
Thank you, Chris, for this detailed presentation. So we have about 45 minutes for questions and answers. We have received quite a few on Facebook already, so maybe I will take 2 from there. Martin asks, I'm British-German dual national. Do I have to confirm my settled status?
No, and as we said, dual British nationals they're not allowed to apply. It's not you can't be given an immigration status as a British national, so you won't. If you have any family members who are just European nationals, they would need to apply, or family members who are non-EU nationals would need to apply. They will still be eligible, but you don't need to do that.
Okay, great. And there's another question from Laura and also Jenny. They ask, which comes up very often, what is the difference between settled status and permanent residency?
Okay, so the really important difference is that going forwards from December 2020 or perhaps June 2021 under the deal, if there is a deal, permanent residency doesn't give you any kind of lawful immigration status. It will become a completely void. And so if you haven't used that permanent residency to apply for settled status, then you're effectively going to be left with no immigration status. So that's the most important part of having a permanent residence document, is knowing that you still need to apply under the settlement scheme. There are the permanent residency will continue to apply to you until EU law ceases to apply, and that depends on whether there's deal or no deal Brexit. But really, it's just the message is you still need to apply. Eventually, you need to be under the settlement scheme, everyone who's got a permanent residence card.
Okay. So do you have any questions? Gentleman here? Sorry, could you please wait for the microphone? Because thank you.
Here you go.
Microphone.
Yeah.
For the streaming, for people online.
Everybody, yeah. It's about permanent residence. There were 2 types of permanent residence. One was de facto. If you'd been working here continuously and lawfully for 5 years, you had it, willy-nilly. However, a few years ago, November 2015, they introduced a rule saying you have to have a permanent residence card document to prove this. And one of the advantages of having that card is that if you have a child born here, they can apply for British citizenship. Now, the question I'm asking is actually fairly simple. Is it worth still, can an EU national who's been here several years still apply for a permanent residence document?
Yeah, okay. It's probably worth clarifying a couple of things though. That the November, the 2015 date, it's not to be understood as you have to apply for a permanent residence card.
Yeah, of course. But
it's to do with British nationality.
Yes.
We went from a situation where you could apply for British nationality just showing evidence of working for 5 years to a situation where the government said, no, you have to first go and get a permanent residence card, then come to us about nationality. That's what the change was. So it wasn't about whether or not someone had permanent residence, but it was...
Yeah, I know that.
Sure,
I know that.
that's not how it's... Sorry, I just want to be clear for everyone else. That's why.
If you wanted that card for a particular purpose, such as passing on...
Yeah.
So
the answer is yes, you could. You can still apply. You'll be able to apply for a permanent residence document up until the point when free movement law finishes, which is either no deal 29th of March, deal 31st of December. The only reason for someone to do so, to go and apply for a permanent residence card, is for that reason, is for proving perhaps that a child was born British.
Exactly,
But you can still apply. But what we don't know is, in a no deal scenario, whether or not the Home Office will honour the application. So if you make an application for a permanent residence document on the 28th of March, and then we crash out on the 30th of March, will the Home Office honour that application you've made and still process it? And we don't know the answer to that question. So
in theory they should, but
it would be nice, wouldn't it, if they honoured things they should do. But yeah, it's you could still do it today, and it is important for people who have had children born here, because a child being born British because the parent held permanent residence means that they're born British, so that's fine. You apply for a passport for that child. If the child wants to become British but wasn't born British, it's £1,000 to register that child as British. So there's a big difference in the cost.
And just one supplement: would they still use EEAPR form, or?
Yeah, or the online form. Yeah, they're still that you can still
under EAPR. It's still called.
Yeah, the paper version is EEAPR.
Thank you very much.
No problem.
Okay. One question from Facebook while the mic gets there. It's related to this one. Michaela is asking, I have a child born in the UK, I assume EU citizen. Do I still have to apply for him as well for settled status?
Yeah, if any person, adult or child, who holds EU nationality alone and no British nationality, or a non-EU family member without British nationality, has to apply under the scheme.
Okay.
So adults and children alike.
There's a question there.
Right. If I was to apply for settled status tomorrow, do they only look back for 5 years, proof of residency? It's just someone had applied and they had been asked for documentary evidence from 2013, which is beyond 5 years.
Yeah, that will depend on your circumstances. So if you're someone who has been living here for the last 5 years or beyond, then in theory you should just be asked, you should be able to get your settled status by showing the last 5 years, because the time before that's irrelevant, because you have a 5-year period. But if you're someone who lived here for 5 years and then has moved out of the UK for some reason, you still are eligible under the scheme, providing you didn't move out more than 5 years ago. So some people, like, again, and it's the same with sort of permanent residence documents, you can apply for them where you have actually stopped living in the UK. But what you'll be asked to show is, show us the period when you were living here, and then show us that you haven't gone beyond the 5 years absence. For settled status for EU permanent residence is only 2 years. But so I don't know about the example that you're talking about, but if that person, like I say, had spent the last year abroad, that's why it could have to go back to 2013. But there's no, if you've been living here consistently, and as of the date of application you'll go looking back 5 years and you've always been living here, that should be the relevant period.
Right. Also, what happens if you apply and you get settled status, and without realising that in one of those years you might have just exceeded the 6 months if you've been going in and out of the country? Because, I mean, you don't necessarily keep records going back 5 years every single trip.
Yeah. So, I mean, what you'll be asked to do, I mean, when you make the application, you'll be asked to self-declare. Have you been outside of the UK in more than 6 months in any one period? And you'll say, obviously, no. It will legitimately, because you won't have sort of, it's an honest mistake, I suppose. in theory, if it was established, then your eligibility for the status that you've been given is perhaps not there anymore, and the Home Office would have a lawful basis to say no, you were given the wrong status, and you know it's not the same as making a false representation because it's an honest mistake, but it could be in principle be taken.
When they change it to any 12-month period, it's very difficult to go back and try to establish any 12-month period.
Yeah, it's a slightly confusing rule because it's not clear which 12 months are we talking about. Are we talking about calendar years? Are we talking about tax years? Are we talking about just years from the date of application? They will probably look at the date of application. But I think it would be, it's quite hard for anyone to establish one way or the other exactly 183 days in a 12-month period. And so, in principle, the way the scheme is written, the benefit of the doubt goes with the person applying that they've made an honest declaration.
Right, thank you.
So we had quite a few questions on Facebook about how EU citizens can travel after Brexit. So Georgina is asking how long EU citizens will be able to travel with ID cards. And Mame asks if you leave the UK and you want to come back after March 30th, do you need to have a permanent residency or any other documentation?
Okay. So in terms of travelling in and out of the UK, again, deal, no deal, there is a distinction. If under the withdrawal agreement, then ID cards are going to be valid, I think it's until 2025, as a way of travelling in and out of the UK rather than having to use a passport. And so that will continue, and essentially there won't be, that will be the method in which you can enter the UK. There's a difference about whether or not you have what immigration status you have, which is important from January the 1st, 2021. It is important to know whether or not you're under the settlement scheme or whether you are someone who's never been resident here and falls under the new immigration system. But the point is that either way, for the on what's been published from the Home Office and the government, until December 2020, there will not be any change in the way that people travel in and out the UK. There won't be any checks, there won't be any questions asked of someone about whether or not there's someone who falls under the settlement scheme or not, even if there's a no deal, because the government's decided that January 2021 is the new immigration system, and up until that point, the easiest thing to do is to essentially carry on as we are today. There's legal differences and there's technical legal differences about how that will work under a deal or no deal, but the result for people, how they'll feel it in practical terms, it won't be any different. So no, you don't need a permanent residence document after or as of the 30th of March this year if there's a no deal, because there won't be any change in which you enter the UK, you'll just do it as normal.
Okay, thank you. That lady there.
Thank you. My question somehow ties in with the gentleman's first question here. We came to this country 10 years ago and recently, or a year ago, tried to apply for citizenship for our oldest son, and that's not possible for some reason. It turns out that when we went to the Maidstone immigration paper checking service and had paid their fee, they said although the forms that we had used were the official government GovDoc forms, there seems to have been a mistake because my husband or I did not have permanent residency, hence we could not apply for British citizenship for our child. The problem is concerning what the gentleman said earlier, that when my husband started his job 10 years ago, he was actually told he doesn't need the permanent residency because he was on a permanent, or it still is on a permanent contract. Since then, this obviously has changed, but when he tried to get permanent residency, once we realized we wanted the citizenship for our child, he was told, don't do it because you will get this new settled status, so there's no point in you now getting the British, the permanent residency, which you now said actually you can still get. So I'm even more confused.
Yeah.
The Maidstone Immigration Service called the Home Office for us 3 times, 3 different people, none of whom was able to say what we should do. None of them knew what the problem is and how we could actually proceed. Very frustrating. Now we don't know, because you just said on one of your slides it said that now that we have the settled status, we would have to wait for 12 months. Is this right? Before applying for citizenship. Now, does this also apply for applying for citizenship for our child? Do we now have to wait for 12 months before doing that, because we would like to do this before he's 18, and then that's out of the question?
Sure.
Sorry.
No, that's okay. I mean, I'm sure that helpfully, probably to everyone, you can see how complex this can get. It's supposed to be a straightforward situation, but it really isn't. We might need to speak at the end, like, just about the exact circumstances, because there's a lot of different things going on in there. But the point is, yes, you still can apply for a permanent residence document. The government's advice after the referendum was people didn't need to do so, because they didn't want a glut of people applying for permanent residence documents, which was what happened anyway. But they tried to divert people away from that from a resource point of view. So it wasn't necessarily the right result for you as a family, but it was generic advice. And unfortunately, it looks like you might have ended up being penalised on the basis of that advice. The difference, I mean, so in terms of settled status, the reason that where it is different from permanent residence is that, again, as the gentleman quite rightly pointed out, permanent residence occurs at a point in time, irrespective of whether you apply or don't apply. It just happens when the conditions are met, whereas settled status only happens once you've applied and once the Home Office has granted it to you. So they're different systems. So if you haven't applied for a permanent residence document, either because you were advised not to erroneously or just because you chose not to, once you apply for settled status, the impact is as an adult, you can apply for British nationality 12 months after you obtain the settled status if you're not married to a British person. Your children can apply immediately to be registered as British nationals if they were born in the UK. So the children can apply immediately once you've got settled status if they were born in the UK. As adults, you have to wait for 12 months before you can apply if you're not married to a British national. In your case, it may be worth still applying for a permanent residence document depending on when your child was born, because your child may have been born British.
Can I ask you afterwards then?
Yes.
It's very complicated. Thank you.
No worries.
Okay, I have one from Facebook, Vincenzo. He's Italian. He has been here since 2005 and has 2 kids with British passports. But his wife is American, living in the UK since 2014. And does she need to apply for settled status, the wife?
2014. So obviously we're in January 2019 is 5 years from January 2014. So depending on when she arrived in the UK will depend on whether she meets the 5-year qualifying period or not. But at some point in 2019, she will have presumably reached the 5-year qualifying stretch, which means, yes, she does need to apply. He's Italian, so they're married, so he'll be effectively acting as a sponsor for the non-EU national. So, yes, she needs to apply, and as does he, if he doesn't have British nationality himself.
Okay.
This may go beyond your expertise, but
I don't know.
there's a nothing goes beyond your expertise. Sorry.
I wish.
There's just this one worry that I kind of keep dragging around with myself at the moment. I'm a German national. I applied for settled status last week. I got it on the next day, so that bit was easy.
Good.
I would like to. I've got a British husband. I'd like to apply for British nationality. There is, however, in the EU, my understanding of how the Germans handle dual nationality is that
you can have it with an EU member state.
Exactly,
Right.
yes. And I'm
okay.
quite anxious about that bit.
So this is a very German-specific answer, but and I'm not.
Only
I am
Germany
not
that does
an
it.
expert in German nationality law, but I have asked the political consul of the German embassy to answer this. And what they are trying to pass laws, national laws, is to say that. So in the event of if there's a deal, you're fine. You have to apply for British citizenship before the end of the transitional period. If there is a no deal, then you need to make your application before the 29th of March. But even if it's not decided, then
We'll find out on the 29th of March.
well, probably about the end of March, we'll know what's happening. But if you make your application before the Brexit day, even if it's not decided before Brexit day, then you won't have any issues with your German nationality. That's what I've been told, and you would have to. You'd have to have that confirmed either by the embassy or a German nationality lawyer. But mine that because it's not been passed as a law yet, but that's the intention. So I can only and that's what was given to me. Like I say, I asked the German embassy themselves. So that is what they've said they're intending to do. But of course, yeah, you need to be very careful because you don't want to be in a situation where applying for British citizenship loses your EU nationality because one of them is perhaps more important than the other. Yeah, no. So, but that's what I know about that situation. Okay, but that's a very German-specific scenario. It's because of the dual nationality issue.
Okay, we have one on Facebook that comes up quite often too. Adelaide is asking, I have been living here since 1973 and I have a letter that says I can live permanently in the UK. Do I need to register?
It's hard to say without knowing exactly what that document is. So I'll have to revert slightly back to the generic point that was made, which was it may be that that's someone who has what we'd call old style indefinite leave to remain, which is a British immigration status. And if the person does hold that, then they don't have to apply under this scheme. But because of it goes back to 1973, if you hand that to an immigration officer at an airport after free movement ends, they might look at it like, what's this? And so go and get settled status anyway. Even if legally you're not required to because of that paper, I would still get it because it will save you a huge amount of hassle in the future, probably.
Okay,
so hopefully that's a practical.
So, lady there.
Is there an ideal date to apply for the EU settled status? As in, is there a benefit to do it now or to wait until the 29th of March? Or is there an ideal date?
There's only sort of situations where it might be beneficial to delay because back to the gentleman whose wife at some point in this year will meet the 5-year residency probably. You may as well wait till you've got the 5 years if it's going to happen before the deadline, because then you don't have to make 2 applications and it's just a practical thing. But does it make a difference? Does it improve the status you get? No, it doesn't. It's like you have to apply. Yeah. There's going to be lots of applications when the scheme first opens. There probably will be lots of applications when the scheme closes. So maybe the middle part is better for people because it will get a quicker outcome.
So I'm a German national and I've lived here since 2003 and just have the German passport, so would be applying for the EU settled status. And I've lived here since 2003 non-stop until last end of February and was registered in Germany to live there from the 1st of March. And I left that residency ended on the 24th of August last year. So it was it's about 5-6 months. But the whole rest of the time I have lived in England and I had my whole education here and I've got a place to study in Cardiff at university in this September, and I was just wondering whether you have any idea whether that affects anything to do with me having the settled status within 5 years, but B, the student finance for that.
Right.
Sorry.
Yeah, no, that's fine. So because you have a 5-year block of time,
yes,
in the UK, so long as you can evidence that,
yes,
you should meet the condition to get settled status, even if you then have an absence afterwards, providing that absence doesn't exceed 5 years.
Oh,
so,
yeah.
So that's how it should work for your situation. So it's just a case of getting together the right evidence.
So it doesn't have to be the last 5 years, it's just any 5 years.
It's any 5 years, providing you haven't then had 5 years absence from
Oh,
the
okay.
UK.
Oh, that's fine. Yeah, that's
So there you go. So
Yeah.
you should qualify for settled status. Once you qualify for settled status, you will, as far as student finance goes, the rules written at the moment is you're a home student as
Okay.
far as fees goes. Bear in mind that the student, there's lots of different things that could happen with student fees. Again, no deal, no deal.
I see.
But broadly speaking, someone who has got indefinite leave to remain, which
Yeah.
is settled status, is subject to home fees,
Okay.
plus the other conditions that university fees, because it's not just about your immigration status, but that would be what would occur in your situation. The government has guaranteed home fees for EU students for a number of years anyway as well, irrespective of what happens with the settlement scheme. So,
Okay. Thank you very much. That's brilliant.
Okay, we have one on Facebook again. Rachel from Spain, she has a fiancé from Nigeria, so a third country national, and they are going to get married in May 2019. Will Brexit affect us? She says that the Nigerian fiancé has a work permit for 5 years as a family member of an EU citizen.
okay, so I'm going to assume from that that this person is living in the UK.
Yeah.
The fiancé is living in the UK. So they've already, if that person's already been granted a residence permit as probably as a sort of durable partner, a serious relationship of an EU national, then that person will qualify for settled status, providing the relationship continues either as unmarried or becoming married doesn't necessarily change the situation. They meet the criteria, so it's just the case of making the application before the deadline and going through the hoops that everyone else has to go through.
Okay, thank you. Is there someone there?
Hi. I was wondering, I'm a student at university and I've been studying here for a year and a half. Would I still be able to apply for the status?
Yes, but because you're an example of someone who won't be able to get the 5 years before the deadline, so you're going to have to apply for a pre-settled status and then make a second application for the settled status somewhere down the line. But yes, you are EU national.
Yeah, Italian.
Yeah, okay, all right, sure,
Okay.
I should have checked. So yes, you can.
Okay.
There's a lady there.
Under a no deal, will there be any limitation for the healthcare we can receive?
Oh, wow. It depends on what you mean by healthcare. So if you're talking about NHS treatment in the UK, then no, settled status or pre-settled status gives you the immigration status that allows you to have access to the NHS, which is, the NHS treatment is partly down to your immigration status and partly down to where you're resident. So you'd obviously need to be resident here as well. So that is unchanged.
What about until we get the status if we don't apply straight away?
In the event of a no deal, then the NHS should be instructed not to just not to make the checks that they'll have to after January 2021. The one thing about the policy about the no deal and what happens to people arriving after Brexit Day and this requirement to register for 3 months is it talks about how employers and landlords and banks aren't going to have to make additional checks or make any checks on people, but it doesn't include the NHS in that list, and we're trying to find out why that's the case. But it shouldn't. You got to think in terms of the idea of not making additional checks is to not disrupt people's lives, so it should apply to the NHS equally. And then after December 2020, people will be asked to show that they have pre-settled status, settled status, to have NHS treatment.
Thank you.
Okay, there is a Hungarian lady has a question on Facebook, Zsófia. Are there any rights that settled status gives you but British nationality doesn't? For example, family unification.
Yes, it gives you more beneficial family reunion rights. So So if you are an EU national under the settlement scheme and you want to sponsor your non-EU national spouse to either stay with you in the UK or to join you in the UK, all you need to do is show that you're under the settlement scheme and that you're lawfully married to that person, and that's as far as the questioning goes. If you are a British national and you want to sponsor a non-EU national to come and live with you in the UK, you have to meet a minimum income threshold. You have to have appropriate housing. That person is probably going to have to take an English language test. So there's more hoops to jump through. Under the settlement scheme, you can sponsor your parents to come and live in the UK if they are financially dependent on you. A British national isn't able to sponsor non-British parents and non-EU parents to come and live with them unless they have extreme health difficulties. So yes, the family reunion rights under the settlement scheme are more generous than what is applied to a British national only.
Okay, thank you. I think there's a question back there.
Hi, my daughter is a student and I apply for the settled status. How is the process for the under 21 years olds? Because when I've done the application through the app, there seems no option for I'm under 21 or something. Because there was some note, she will need my reference number.
Yeah.
So what is the process of applying for the under 21?
So just, is your daughter an EU national herself?
Yes.
Yeah. So essentially what that means is anyone who's an EU national can apply in their own right. You don't need to prove a family relationship if you're under 18 because you're an EU national. So you may have 5 years of qualifying yourself. If you want to link yourself to an application because it might make it easier from an evidence point of view, then when you apply, you'll be given a unique identifier, and then your daughter can use that to show that she's related to you, and then they'd ask for a birth certificate as well. Okay. And it would link her application to yours, which may make life more straightforward, it may not. But the idea of linking an application to someone who is an EU national is more relevant where the person applying is not an EU national themselves, because they need to find an EU national to link themselves to, because otherwise they can't apply under the scheme. So that would normally be the purpose of asking for an EU national relative's unique identifier. But it could benefit your daughter, but if she can prove 5 years in her own right, it's irrelevant that she's over 21 or under 21 because she's an EU national who falls under the 5-year rule.
Okay. Thank you.
Okay. We have a question from a Belgian citizen, Anya. She's asking, should I exchange my Belgian driving license for a British one after Brexit?
Okay, yeah, so this is very much not part of the settlement scheme, but the general rule is that once you've lived here for 3 years, you should swap your EU driving license for a British driving license.
Okay, that was easy.
So, and there will, essentially there's no change, even under a no deal. The UK government has said there'll be no change to anything to do with EU nationals driving in the UK. So the rules that apply now, which includes that 3-year conversion rule, applies post-Brexit. There's not going to be any requirement for people to go out and get international driving permits to drive here. The government's just not interested in that. So same rules apply as they would today, even in a no deal, according to the Brexit note that they've published.
Okay. I think there was a question here.
Sure.
There.
Hi, I've been granted the settled status, but I was wondering, can you apply for the citizenship straight afterwards, or is there you still have to have been here for 6 years?
Okay, so are you married to a British national?
No.
Then you have to hold your settled status for 12 months, and then you can apply for British naturalisation as a British national.
After.
So it probably will equate to 6 years in total.
Because I would have been here for 6 years in April, but I have to, with the permanent residency, I could have applied straight after I got the permanent residency.
Yeah, if you've already been here 6 years, then you could go now, you still could, you're not prevented from it. You can go and apply for a permanent residence document which shows that you got permanent residence at least 12 months ago, and if you got that, you could apply for naturalisation today, subject to the other criteria. But it means going through the permanent residence process and getting that document, and you do have to pay the £65 to do that.
Yeah.
So it really depends on how eager are you to become British.
I've got the same problem as the German lady earlier, that I'm under the pressure. If there's no deal,
yeah,
I might not be able to have two citizenship.
Sure. So, I mean, so then the only option you have is to go and try and get a permanent residence document issued before the 29th of March, which says you've got permanent residence for over 12 months, and immediately apply for naturalisation. So it's just about possible, but you're really up against it, I'm afraid.
Okay, thank you.
Okay, we have one on Facebook, Mihai. He's a Romanian citizen, and he has been in the UK for 2 years. 1 year worked with a contract, and now working with an agency. Do I have the right to stay after Brexit? That's an easy one.
Yeah, thank you. Yes, you are. I don't know why I'm talking to, like, you're there. I assume that there's a feed to yeah, absolutely. Doesn't matter. The work is irrelevant. Providing you've got no criminal issues, then you'll get pre-settled status, not settled status, because you don't have the 5 years, but it'll all be fine.
Okay.
And deadline to apply. Again, remember the deadline.
I think there was a gentleman here. Yeah.
Hello, yeah. Further to crashing out in the spring, an EU national who doesn't apply for settled status until next year because it's not in their advantage to do so, wait, 5 years doesn't culminate until next year. Your answer about the NHS wasn't entirely clear because, as you said, there's not 100% clarity. Do you foresee a situation where, for example, if that person required medical treatment between April of this year and April of next year, before they make their settled status application, that there could be some confusion, NHS admin being what it is?
Yeah, yes. Unfortunately, so look, I mean, the fact of the matter is, even at the moment, the NHS sometimes will refuse EU nationals treatment. So that isn't going to go away when you're increasing the confusion about the situation. So if you really were sort of saying, okay, what do I do to absolutely mitigate this, is even if you can't get settled status, get pre-settled status.
That's the one advantage. So your point about waiting for the 5 years, I see that point in terms of the administrative burden, but covering your backside with the NHS possibly.
Sure. I mean, the point is the NHS shouldn't refuse treatment to anyone who is legally entitled to that treatment.
Yeah.
So that's in a perfect world. But we don't live in a perfect world.
No.
And so you might decide that actually I'm concerned enough about that I would rather go through 2 applications to get pre-settled and settled than wait. And that's a personal choice, but I would totally understand why someone would do that. But legally, they shouldn't have to.
And I mean, do you foresee next year the system crashing, or you're quite positive in the way it's been sort of...
Sorry,
you're quite optimistic, so I got the impression.
Are you positive about... Sorry, about...
About the settle schemes, about the Home Office and the scheme that's just been rolled out, even though it's Android only and so forth?
I think that I mean, this is a total my own view.
Yeah.
I think that the vast majority of people will be fine with the system and it will be okay. There is always complexity. I mean, you've seen how complex it can get.
Yeah.
And that's me trying to make it simple, and it's not. It comes across as sometimes complex, and so where some people are going to really struggle to negotiate this, and I've got concerns about how vulnerable people will have access to this scheme, and whether or not there'll be enough information out there to make sure people understand that they have to do it. Of course, I've worked with the Home Office. I've worked involving the Home Office for best part of 15 years. So sometimes you see things that you'd rather not see.
Okay. Thank you.
So we have time for 2 more questions. There was someone there.
Hi, yeah, it's me. So in terms of qualifications, so if someone wants to come and work here, deal or no deal, if it's like a EU national, will there be a problem with the qualifications, like, you know, degrees or stuff like that? Will there be still recognized, or?
Yeah, so this is one where deal or no deal will have quite a significant impact. Under a deal, then qualifications obtained in, and this is professional qualifications.
Professional, yeah.
Probably more than overseas degrees, because those can be compared relatively easily as far as sort of the education side of it. But in terms of professional qualifications, the idea under the withdrawal agreement is that the current mutual recognition of qualifications would continue at least through the transitional period, and for all, because people still have to apply to have their professional qualifications recognised, but anyone who made that application to have it recognised before the end of the transitional period would still go through that process. After the transitional period, it's a different story. But obviously that gets moved to Brexit Day in the event of a no deal. So if someone's applying to have their qualification recognised before Brexit Day, that process will continue. And afterwards, there is a policy paper on it, and the government indicates that they will still continue to recognise professional qualifications, but there will definitely be a change at some point. And the problem with any of this is it sort of requires some kind of reciprocal agreement on the other member states to have the goodwill to do that. But the government has indicated they will continue to recognise qualifications in most categories. If you're a lawyer, then it's very different.
So if, for example, you have an offer for a job, and then you have to move to UK, and, for example, your qualifications are accepted and everything is fine, and do you have to apply for a visa, you said, if you haven't been living in the UK, obviously, so you have to apply.
So yeah, so in a no deal after Brexit, not being resident at any point before Brexit, you will enter in the same way. You can take employment without having to get, and your employer is not supposed to ask any more questions.
Okay.
If this happens before the 31st of December 2020, and then, but the onus is on you to apply to register with the Home Office within 3 months of your arrival, even though your employer is not going to ask you to do so because they're being told not to.
Okay.
And then, but you're only...
That's with no deal.
That's with a no deal.
No deal, yeah.
But what you'll be given, if you do register, you'll be given a 36-month-long visa with no opportunity to settle permanently unless you can find another immigration category to fall into, which is not part of the settlement scheme.
So let's say within these 3 years you get married to someone that has got the settled status.
Yes.
Then you will be eligible to...
If your marriage took place before the 31st of December 2020, then under the no deal settlement scheme they can sponsor you. If your marriage took place after the 31st of December 2020, then you would be under the current immigration rules that apply to British citizens.
Okay.
So it would depend on the date of the marriage in that specific scenario.
I mean, it's after 2020.
So the marriage is after 2020?
After, yeah. Well,
So they can't sponsor
hypothetically.
They can't sponsor you under the no deal settlement scheme if that's someone who's under the no deal settlement scheme, if the marriage took place after December 2020.
Oh. Okay, thank you.
Okay, thank you. So we have to wrap up. Thank you for your attention. And I would say that you mentioned a few resources, but there is this new website which has been launched recently, eurights.uk. You will find many resources on that too. eurights.uk. That's quite useful. Okay, thank you for your attention.
Thanks.
Thank you. Okay, now comes the attack.
I was going to say, my 25...